Hi, folks. My name's David Ward. I'm an attorney at Legal Voice, which is a nonprofit organization that works to advance women's rights in the Northwest. And I'm going to be doing the next session, and what I'm going to be talking about is domestic violence and LGBTQ relationships. In the clinic that we do in Seattle, we get a good number of referrals of clients who've gone to DV agencies and need legal help. And I think it's important to have a good background on DV as it affects LGBTQ couples because domestic violence is something that is very prevalent in all relationships, regardless if it's a same-sex relationship or an opposite-sex relationship. And the Civil and Legal Needs Study that was just released by the state of Washington found that domestic violence survivors have at least on average 19 separate legal issues to deal with, more than any other folks. So domestic violence is important for clinic volunteers, I believe, to have a good background in it. So I'm going to give a 1-hour session on this. I do want to give an acknowledgement to Amaranthia Torres at the Northwest Network of BTLG Survivors of Abuse. The Northwest Network is an agency based in Seattle that specializes in working with LGBTQ domestic violence survivors. It's a nationally recognized program, and they have tremendous resources on their website, which I list at the end of this presentation. But it's a fantastic organization. Amaranthia and I did this presentation together when we did a Q-Law CLE in April. She wasn't able to be here today, so I am borrowing some of the content from her slides for today's presentation. One question we get asked a lot is, how often does domestic violence occur in LGBTQ relationships? All the studies that have been conducted, including the one I cite here, show that domestic violence is roughly equal in prevalence to domestic violence in heterosexual relationships. About 25 to 33% of relationships involving LGBTQ couples involve domestic violence. So if you are seeing a client at a clinic on a family law matter, there's a good chance that domestic violence is an issue in the relationship. One of the issues that is a particular problem in LGBTQ relationships and dealing with domestic violence is the law enforcement response to it. The study has shown that if a domestic violence call is made to a DV situation involving a same-sex couple, it's 10 times more likely that law enforcement will arrest both of the partners when they respond to a call. There are a variety of reasons for that, but I think a major reason is that law enforcement is generally not well trained to deal with domestic violence in involving same-sex couples. They may just think both are at fault, and they can't decide who is the primary aggressor, and they'll just arrest both parties. This makes it even more reluctant. This makes a lot of same-sex couples or same-sex survivors of domestic violence more reluctant to call the police to respond to DV incidents. I want to talk a little bit about language. In the domestic violence community, those of us who work with domestic violence survivors, we do use the word survivor generally versus the word victim when we describe somebody who has been a victim, but of abuse. And the reason for that is twofold. One, it does reflect the fact that survivor is a more empowering word, we think. It also reflects what has happened to the person. And we define a survivor as a person who experiences a pattern of power and control by another. I'm going to get into this more as we go along, but domestic violence is about power and control. It's not just about hitting. It's not just about an incident that might occur once. It's about a pattern of control established over time, where an abuser, which is the term we prefer to use, seeks to maintain control over often every aspect of a survivor's life. The criminal legal system, by contrast, uses language like victim, perpetrator to describe the abuser. And the criminal legal system also tends to look more at snapshots in time, where the police respond to a domestic violence call, for instance. They don't look at the whole history of the relationship necessarily when they're determining who to arrest, who's the perpetrator. They only go off of what they see. Who might have bruises, who might have bite marks, who may be the one who appears to have been attacked. And in reality, and this is common, a lot of times when somebody is charged with domestic violence, they are actually the victim or the survivor. And they might have just been defending themselves against an attack, but have managed to be trapped into the system as what we call a victim defendant. And I think it's important when you're seeing clients just not to judge off the bat if somebody says, I was arrested for domestic violence, he or she got a protection order against me. Because it is very, very common, again, for victims to be misidentified as the perpetrators. Now, abusers use a lot of different tactics to establish power and control over survivors. Many of these are not illegal. Some of them are. Obviously, if you hit somebody, if you threaten somebody, if you force sex on somebody, that meets the legal definition of domestic violence in Washington state. But doing things like isolating a victim, establishing such economic control over them, not letting them work outside the home, not letting them see their friends, taking all their money, maintaining all the bank accounts in your name, taking their passport. Those are tactics of control that aren't really illegal, but they are very common types of tactics that abusers use. In the DV community, the domestic violence community, the power and control wheel is often a shorthand way that people try to explain the various different types of abuse and the ways that abusers can maintain power and control over survivors. This includes a lot of different things. This is a domestic violence power and control wheel that's keyed to abuse in LGBTQ relationships. And I'm afraid it's not going to show up well in your slides, but we do have this as a handout where it's blown up where you can actually read it, and we'll have those in the materials. But it includes things like economic coercion, isolation, and other forms of abuse that abusers use to keep survivors from escaping relationships. In the LGBT community, survivors face some unique tactics that abusers can use to leverage the fact that folks are in a same-sex relationship. And I'm going to go over some of them in particular here, one by one. The first one, isolation and outing. The threat to out somebody, as we all know, can be a very powerful threat. If you haven't come out yet to your families, your friends, if you grew up in a community that very much disapproves of homosexuality or transgender status, trying to out somebody can be a threat that an abuser can use very effectively to prevent somebody from leaving a relationship. This is particularly true when somebody's first coming out. Folks who are just coming out are very vulnerable to abuse and to getting involved in relationships that are abusive. Using vulnerabilities. This is one that might not seem apparent, but a very common tactic in LGBTQ relationships where there's domestic violence is that the abuser uses his or her own vulnerabilities to make the survivor feel obliged to him or her, to feel like, you must take care of me, you can't leave me because of all the discrimination and stigma, for example, we've experienced as gay, lesbian, bi, and trans people, and use those vulnerabilities in order to prevent the survivor from feeling that they can leave the relationship. I think that's another thing to recognize in domestic violence relationships is it's often talked about cycles of violence and cycles of abuse, and reconciliation is extremely common in domestic violence relationships. It's not always awful. The abusers can be very loving and very regretful after an incident of abuse has taken place. The survivor will think, well, something's changed, things have gotten better. And that's why survivors are often asked, why didn't you just leave? Why didn't you just end the relationship? And one of the reasons is there is a pattern of reconciliation and regret that the abuser expresses, but then it reverts to the same old patterns. I think it's very hard sometimes for lawyers who are not trained in domestic violence, who work with survivors, to understand, why don't you just leave? And there are often many reasons why somebody can't leave, but that's one of them. Internalized oppression is another barrier that many survivors in LGBTQ relationships have to leaving a relationship. Folks, we all have, I think, in the LGBT community, internalized homophobia or transphobia, regardless of where we are. And folks, particularly who are coming from backgrounds where, again, homosexuality might be strongly prohibited, may feel self-blame about abuse that occurs to them in a, sort of like, this is what I deserve for being gay, lesbian, trans, or bi. Community members often, too, are very unwilling to disclose abuse because we don't want to make the community look bad. We don't want to reveal the fact that DV does occur in LGBTQ relationships. We don't want to feed into stereotypes about LGBTQ relationships that they're somehow, we want to present a perfect face in many cases, and that is another barrier sometimes to reporting abuse and leaving relationships. Using children is a very powerful tactic that abusers can use if a couple has children together. In particular, the non-biological parent can be very vulnerable to threats that if he or she leaves, the abuser will take the children away. This is particularly true if a non-biological parent has not yet established a legal parent-child relationship with the child. Small communities are another special barrier that people in the LGBT community face when involved in a domestic violence relationship. In many communities, there are, only one or two bars that people may go to. I think I might be dating myself when I say this because I don't know how important the bar community is anymore in the LGBT community, but in some communities it is a main social gathering place, or there may be very few safe spaces or welcoming businesses, community centers, churches, other places where LGBT folks congregate. And if you have a situation where there's a very small community, it's very easy for the abuser to track and to stalk the survivor and to keep tabs on them and to get information about them. I'd also say institutional violence is something that we have to keep in mind. I alluded to this a bit earlier when I started, but there's an understandable reluctance for many LGBTQ survivors of violence to go to the police, to go to the hospital, to go to a mental health care provider, to seek help and to seek help in the courts even, because they fear how the system will respond. I think this is a concern that still exists. I think a lot of people are still afraid to call the police, still afraid to go to court about how they'll be treated. Will the court get it? Will the police get it? Even will my healthcare provider or a DV advocate get it? And substance abuse is another issue of special concern. As a whole, the LGBT community does have higher rates of alcohol and drug abuse, about over 20% compared to about 9% in the general population. And there are many reasons for this. A lot of people have used alcohol or drugs as a way of sort of coping with the stigma and difficulties and discrimination they experience as LGBTQ folks. There's also the fact that, again, typically in many communities, the way that LGBTQ people have found themselves have been in places like bars or in other more marginalized spaces. So that's a very, very fast overview of some of the unique issues that LGBTQ people may face with domestic violence. I want to talk now about what the law is in Washington State on domestic violence, focusing on civil legal issues and civil remedies for survivors of domestic violence. I'm not going to really get into the criminal aspect. As our clinic, we do not deal with criminal issues. We only will be able to advise people on civil legal issues. Now, good news is, and this has been true for a long time, Washington State's domestic violence laws don't distinguish between different sex or same-sex couples. The law applies equally to both, and the same protections apply equally. As I've alluded to before, though, the reality is that many survivors still do experience discrimination and stereotyping when they're seeking help from law enforcement and courts, and that is something to keep in mind. I can never advise a client that your judge that you go before or the commissioner you're going to go before is going to get it, that they're going to treat you fairly, that they're going to treat you equally. And it's something to keep in mind. Washington State has established a variety of what we call civil protection orders that are available for survivors of various types of abuse. These are orders that are basically restraining orders. You'll often hear that term used as well too, where you can get an order from a court that prohibits somebody from coming within a certain distance from you or from your children. Part of the complexity we have on advising people about protection orders is we have a lot of different types of them in Washington, and courts can be very strict about you're seeking the wrong order and actually will tell you, this isn't the order you need to get this one. So it's important to know the different types of protection orders we have. The first one I'm listing are domestic violence protection orders. These are authorized under RCW 2650. These are orders that you can get if you have been a victim of how domestic violence is defined in the statutes by spouse, a partner, somebody you have a child in common with, somebody you're in a dating relationship with. If there's been physical abuse, the threat of a physical abuse, sexual assault, or stalking by somebody who's an intimate partner. Sexual assault protection orders are available to protect yourself if you've been sexually assaulted by somebody. It's a civil order that you can get based on a preponderance of the evidence. You're only supposed to seek a sexual assault protection order if you would not qualify for a domestic violence protection order, meaning you should only seek a sexual assault protection order if you've been sexually assaulted by somebody who you are not in a relationship with, including a dating relationship. That can sometimes be hard to judge where the line is, but certainly if you've been sexually assaulted by a stranger or somebody who's just been a friend or an acquaintance, a sexual assault protection order is most likely the type of order we'd advise somebody to seek. We also have what are called anti-harassment protection orders in Washington. These are orders that you can essentially get to prevent somebody who's been harassing you. Not physical violence, maybe not threats of violence, but somebody whose conduct amounts to harassment. These are often orders that people too get against their neighbors because their neighbors are being awful. Courts are not always very fond of anti-harassment orders, but they are another available remedy. And sometimes, if there has not actually been physical violence in an intimate relationship, an anti-harassment order might be a tool that somebody can use to at least keep an abuser away from them. And recently, to make things even more complicated, the Washington legislature adopted stalking protection orders 2 years ago. These are orders that you can get if you are being stalked by somebody who, again, is not an intimate partner or somebody you've been in a dating relationship with. I think the case that motivated this law being passed was the case, I think, out of Pierce County, where I think a teacher was being stalked by somebody who knew her but was not an intimate partner of hers. I think eventually killed her. And a stalking protection order is designed in cases where basically you are being stalked by somebody who is not an intimate partner. And it again has the same effect of being able to keep the stalker away from you. And despite even going through 4 different types of protection orders, we even have more different types in Washington. I'm not going to go over these so much because they won't be as relevant for clinic matters. But if you're going through a divorce or if you're trying to get a parenting plan for a child you have in common with somebody you're not married to, you can seek a restraining order as part of the final orders in the dissolution or in the parenting plan. We also have vulnerable adult protection orders, which are available in cases where usually an elderly person, but also people who are not necessarily competent to make their own decisions, are suffering abuse. And in criminal cases, the courts can issue a no-contact order, which again is essentially a type of restraining order, but this is only available if you have an active criminal case going against the abuser. So what can protection orders do? The levels of relief vary a little bit depending on which type of protection order you are seeking, but in general, protection orders can prohibit respondents from coming within a certain distance of you, including your home, your workplace, or your school. It can prohibit the respondent from committing further unlawful acts against you or your family members. And depending on the type of order, it can do other things. For example, a domestic violence protection order can be used to establish a residential schedule if the abuser and the survivor have children in common. For up to 1 year, it can establish a residential schedule. So the process for getting a civil protection order in Washington, in general, again, it's intended to be a very accessible system where you can do it without a lawyer. And in fact, most people who do seek civil protections are pro se and don't have a lawyer. Like Terry alluded to earlier, mandatory forms, we use them in Washington state, and mandatory forms must be used for seeking different types of protection orders. When you have a protection order hearing, courts do not need to apply the rules of evidence, so hearsay can come in. you don't have to authenticate documents the way you might in another different matter. And again, the reason for that is to provide an effective form of relief for people who are not lawyers and who do not know the intricacies of how you offer evidence or how you can avoid hearsay. Procedures at hearings on civil protection orders vary a lot from court to court, even from judge to judge within a court or commissioner. Some judges will want to hear live testimony from the parties. Others will just do it on the papers. And there's been some case law on this, and generally due process is satisfied. It's a flexible concept in these hearings. But I know at least in King County, judges often do domestic violence protection orders based just on the affidavits of the parties, and that's been upheld as a permissible way to do it. In order to get a civil protection order, again, some basics. It started by filing a petition in the court. I'll go over which court you file in for the different types of protection orders, but for a domestic violence protection order, you have a lot of options. You can often go Superior Court, District Court, or Municipal Court. No charges can be made for filing a domestic violence petition in Washington. And what happens is typically when you seek a protection order, you file the petition. Folks will often seek ex parte a temporary protection order that can last up to 14 days. Law enforcement is supposed to serve protection orders unless the petitioner opts for another method of service. And if the process works the way it's supposed to and the petition for a protection order has timely been served, there should be a return hearing where both parties have an opportunity to be in front of the court within 14 days of filing the petition and seeking a full protection order. At the hearings on protection orders, the courts can realign the parties. For instance, the court can come in and see that the person who's claiming to be the victim is actually, based on the evidence, looks like they are the abuser. And the courts can realign the parties and essentially say, I believe the respondent in this case is actually the victim. I'm going to grant the protection order to the respondent rather than to the petitioner. We've had a lot of problems over the years in Washington with some courts issuing mutual protection orders in cases. This is where a court will essentially throw up its hands and say, I can't decide who the abuser is here, so I'm just going to issue protection orders for both of you. Both of you stay away from each other. Washington statutes have been changed to say that should not be the practice, and to say that you should only issue mutual protection orders if both parties have actually sought their own protection orders. And that, again, is a way to really require the court not just to say, as law enforcement sometimes do, is we can't tell who the abuser is, so both of you just stay away from each other and that'll solve the problem. Just wanted to give some important considerations about protection orders. They are very important tools. At Legal Voice, we fought for years to establish protection orders, the protection order process, to keep it strong, to keep it as a vital remedy for folks. But you do have to recognize that a protection order is not a magic solution to anything. And it's not always the right solution for every survivor. It's not like when there is a tendency to just say, oh, you've been a victim of domestic violence, you should go get a protection order, period. Survivors are often told that by various agencies, such as DSHS, if there have been issues about parenting, or they'll be told by police, get a protection order, get a protection order. As advocates, we don't take that approach. We offer it as an option and can explain the process, but we don't say you must get a protection order. It's not the right response for every survivor. Sometimes getting a protection order can actually endanger a survivor more by angering the abuser, by leading to retaliation against the survivor. We should never presume as advocates that we know what's best for the survivor and that we know what it takes to make them safe. The survivor is generally in the best position to make those determinations about what the safe course of action is. And I think it's also important to understand the hugely important role that domestic violence advocates play. We have a great network of domestic violence advocates throughout the state. They're very devoted. They are generally very well trained, including on LGBTQ issues. I've done a number of trainings for DV advocates on LGBTQ issues, as has the Northwest Network. And advocates are just fantastic. And The one thing I always do encourage somebody, and when I'm dealing with somebody who's in a domestic violence situation, is to suggest you do get in touch with a domestic violence advocate, because they can deal with safety planning, they can deal with issues where we are not necessarily well trained as advocates or as attorneys in economic relief that they may be able to seek in other practical forms of getting and staying safe. So I'm going to drill down a little bit more on the different types of protection orders. For a domestic violence protection order, I've put up on the slide here what the definition of domestic violence is for purposes of getting a domestic violence protection order. And as you can see before, it involves not everything that we would consider to be domestic violence from a behavioral standpoint, but from a legal standpoint, domestic violence is essentially defined as physical harm or the threat of an imminent physical harm, sexual assault, or stalking. And it's domestic violence if any of these things are committed in the context of a relationship between what we call family or household members. That in turn leads to the definition of what is a family and household member under the DV laws. And this is not an exhaustive list. I put a cite to the statute that has the complete definition. But it's important to know it does apply to current and former spouses and domestic partners, adults who are presently residing together or who have resided together in the past. So, if you were living with somebody, the person you were living with is considered to be a family or household member for the purposes of this DV statute. And it also applies to dating relationships between persons who are 16 or older. Now again, every time we put a term in a statute, you have to look at what does that mean. And dating relationship is defined in the statute as a social relationship of a romantic nature. Specific factors that courts can consider in deciding whether a relationship is a dating relationship is the length of time the relationship has existed, the nature of the relationship, and the frequency of the interaction between the parties. And again, there can be a fine line between determining what a dating relationship is, and I don't know if courts are always well tuned to how LGBTQ relationships might work and what a dating relationship might be considered in the LGBT community versus the more traditional. What am I saying? I'm like there's no courtships these days anymore, or I don't know I have no idea what dating relationships look like for teenagers this day generally. So, but it's one of those things that has a definition in the statute that you can look to, but it may have some different applications in the phone. And somebody was holding up a phone to show me that indeed, yes, much dating. Yep, they text each other. Sometimes they sext each other, which is not a good thing, but it does happen. Snapchat seems to be very popular these days, and I really feel like I'm not going to talk any more about this because I'm really going to date myself. So I mentioned before sexual assault protection orders. Again, these are a remedy if the petitioner has been sexually assaulted by somebody and would not qualify for a domestic violence protection order because they were sexually assaulted by somebody who's not considered a family or household member. In the LGBT community, and I will say, again, I might be stereotyping, but particularly among gay men, there is a culture in some respects of hookup might be the word to use for it, but meeting somebody for sex, somebody you haven't had a prior relationship with, somebody you might have met online, and if a sexual assault occurs in that kind of a relationship, and I hesitate to use the word relationship because it's not really the right word, but if somebody is sexually assaulted by somebody they just met for the first time or don't have a dating relationship with, a sexual assault protection order can be a remedy for somebody who's in that situation, who's been sexually assaulted by somebody who they don't really have a dating relationship with or a stranger. Of course, you have to be able to serve the person, so you do have to have information like the name and be able to serve the person with the orders in order to be able to seek relief for this. Anti-harassment protection orders, as I mentioned before, this is a remedy if the petitioner has been unlawfully harassed by another person and would not qualify for another type of protection order like a domestic violence protection order or a sexual assault protection order. Unlawful harassment has it's not a dense definition in the statutes, but I've put it on the slide here so you can see what it is. It essentially has to be a knowing and willful course of conduct that's directed at another person that has the effect of seriously alarming or annoying the other person and has no legitimate purpose. The courts in Washington state seem to really hate unlawful harassment petitions. The Superior Court judges got a bill passed a couple years ago that forced almost all unlawful harassment cases into district court because I think they were just sick of dealing with them. And I shouldn't be so cynical about this, but this is, an unlawful harassment petition is something that's often sought against people's neighbors or people who are bothering you. You know, the dog's barking, they're putting their garbage on my lawn, I don't know. But unlawful harassment petitions are kind of a weaker remedy for that reason. Unlike a domestic violence protection order, for instance, there's no mandatory arrest provisions if somebody violates an unlawful harassment order. Law enforcement has traditionally not been so eager to enforce unlawful harassment orders that are entered. He's putting the garbage on my lawn again. Come please. And it's not the most powerful remedy. And because of that, that's one of the reasons why the legislature passed the Stalking Protection Order bill a couple of years ago. The reason for this is because before the Stalking Protection Order law took effect, if you were being stalked by somebody who was not a former intimate partner, your only remedy civilly against that person was to get an anti-harassment order. And because anti-harassment orders didn't have mandatory arrest provisions and are not considered very powerful tools and are often, viewed as the lowest enforcement priority by law enforcement, it was felt we needed a different type of protection order that specifically addresses cases where somebody is being stalked by somebody that they're not in an intimate relationship with, and to put some teeth into the statute. For instance, under our if you get a stalking protection order and the stalker violates an order once it's entered, they are subject to mandatory arrest by the police, and there are severe consequences for that. And it's meant to provide a stronger tool to protect stalking victims, which did not exist before. And again, the definition of stalking conduct is laid out in the statute for the new Stalking Protection Order law, and it's again pretty dense, but it covers a lot of different kinds of conduct. I'm not even going to try to go through it all, but again, if you are facing a situation where you have somebody, and this is not, again, it's not uncommon in the LGBTQ community for people to be stalked by somebody that they don't really know well, that they haven't had a dating relationship with, and they may need this as a form of relief because it can be, again, a very effective way to stop stalking behavior. Saying this all again, I know there can be some level of cynicism about how effective protection orders are. I mean, the most common thing I hear is it's just a piece of paper, and that's true. But it is a piece of paper that for many survivors can be a very important way to get law enforcement involved, to actually interrupt the behavior, and to give a much greater level of protection that they would have had if they had not gotten it. But again, if somebody is determined to hurt you, if somebody is determined to stalk you, it is true. A protection order can't stop a bullet. So along these lines, in addition to the different forms of civil protection orders that have been adopted in Washington state, the legislature has taken a number of other steps to try to help survivors escape abusive relationships and to give them some economic protections in order to be able to break the cycle of abuse. One of the things the legislature did was establish specific housing protections and rental housing for survivors of domestic violence, sexual assault, and stalking. Under our laws, if you're in a residential lease, say you're in a lease that's a 12-year term, and you are living with an abuser, the survivor can break that lease early without penalty under Washington law. And they can do that. The Northwest Justice Project's Washington Law Help has a very good packet on the forms you need to fill out in order to do that. But it's a fairly simple process where just based on your own declaration that you are a victim of domestic violence, or you get a protection order, there are various ways you can prove that you're a victim of domestic violence in order to break a lease early. Washington law also explicitly prohibits discrimination in housing against people based on their status as a victim of domestic violence, sexual assault, or stalking. And that's important because some landlords just don't want to rent to domestic violence survivors. They think that they'll bring violence into the building, that they are going to be more difficult tenants. And when you have that level of discrimination again, where is the survivor supposed to go? Washington also has some employment protections for domestic violence survivors. In 2008, the legislature passed a law that provides that employers must allow domestic violence, sexual assault, and stalking survivors to take reasonable unpaid leave from work in order to deal with the consequences of domestic violence and to hold abusers accountable. That means a survivor, for instance, can take unpaid leave from work, and it can be intermittent leave to do things like go to court appearances, to testify against an abuser, to go to counseling or medical appointments related to dealing with domestic violence, to getting the family safe in terms of relocating. The survivor is expected, if feasible, to give at least a day's notice before taking leave for these reasons. So it's important, if somebody is asking about this, to take a look at the statute and the administrative rules that apply to this. But again, it's a step forward in allowing people not to get fired for this. Legal Voice had a client who testified in the legislature in 2008 to try to get this law passed, and she had been fired from work after she had to take leave to get her family safe, and she helped to make a difference by getting this law on the books. It is still unpaid leave. In the city of Seattle, and I'm not sure about the city of Tacoma, we also have paid sick and safe day laws, and the safe day laws of that means that employers, this is not a statewide law yet, but employers would have to give people paid leave to the extent they've earned it already to take safe time in order to get, to again deal with the consequences of domestic violence, sexual assault, or stalking, and to hold abusers accountable. There's another important economic protection for survivors who need to leave work because of domestic violence or stalking. Under Washington law, generally, if you quit your job, you usually can't get unemployment insurance. There are a few exceptions, and one of the exceptions is if you need to quit your job in order to protect yourself or a family member from domestic violence or stalking, you can get unemployment insurance in those situations. And it's important to be able to advise survivors in these situations that, yes, you can do this. The Department of Employment Security has been extremely good in implementing this law, and they will not ask a whole lot of questions. Usually, the survivor's word on this is enough that, yes, I had to leave work because of domestic violence. And there may be reasons, some of the reasons you might have to do this is you need to escape an abuser, and work is the one place that he or she knows where to find you, so you can no longer work at that place in order to get safe. Terry mentioned this earlier in his presentation, but I did also want to highlight to folks that we do have what's called an address confidentiality program in Washington. And this allows a survivor of domestic violence to get an alternative mailing address, a P.O. box, through the state of Washington where they can get mail and other notices from the state for benefit programs, for court appearances, so that their address will be protected more from abusers. So I did a couple hypotheticals that I will say this first one is actually a composite. It's a composite of at least 3 clients I've seen at the legal clinic in Seattle that involve some of the issues that have been raised by folks who visited us. So I'll just read it really fast and say, Alan and Bob meet online. They hook up and meet again a couple of times. When Bob stops responding to Alan's request to get together, Alan starts sending Bob text messages threatening to out him to his parents and to post intimate photos of Bob online. So if Bob comes to the clinic, what kind of issue spotting or advice might we be able to give him about ways that he can address this threat? Any thoughts? I can do my own thinking out loud for you because I've thought about this before. But we have actually had clients who come in with situations like this. And I think it is going to be more and more common in an era where people are meeting through the internet, and there's a lot of different ways that you can harass somebody or threaten to harass somebody. In a situation like this, I think one remedy is, do they have a dating relationship under our domestic violence laws? I would think so, but can't be certain that a court would. It's 3 times getting together. Did I say 3? Yeah, about 3 times. Is that enough for a dating relationship, especially if you're just getting together for sex? What will a court do with that? I don't know. But if it is considered a dating relationship, Bob could seek a domestic violence protection order based on this as an example of stalking behavior, I think. Or maybe it's not stalking behavior. It's hard to tell. The safer remedy would probably be to suggest that he get an anti-harassment order, which again is not a very powerful tool, but it is something at least. And some courts in Washington have been very good about taking these kind of cases seriously and saying, I'm going to put in this anti-harassment order that you cannot distribute intimate images of this person that may be in your possession. It's a little harder, though. Could a court actually tell Alan that you're prohibited from outing Bob? Would there be free speech issues with that? Probably. And I'd ask for it, but I don't know if you get it, and I think there might be some constitutional issues there. And that's why outing is such a particularly powerful threat. What can you do about somebody who threatens to out you? It's not defamatory to do it necessarily. It's very injurious. You might have a tort remedy for outrage if somebody outs you against your will, but again, it's a very powerful tool that they can use, and it's hard to get at. Yes?
More to do with intent, though, should they? The intent is harm.
Yeah.
Not to speak. Maybe you could say that by stalking is now we have rights to hang out in front of people's on public streets and to look at things on Facebook. It has to do with intent.
Yeah. The comment from the audience noted that this is a lot of this is about intent, and there are many other ways that may not be illegal that you can stalk somebody, and those kind of behaviors based on somebody's intent to harm or threaten or coerce somebody can be viewed as behavior that a court can prohibit. So I think that is a good point to make, that the argument I think you'd make to a court is the intent here is not to serve any legitimate purpose, it's to harm me, and you should be able to prohibit this. But again, when courts get into anti-harassment orders and these other types of protection orders, it can be very hard for courts to know where to draw the line. One common situation that we see at Legal Voice is immigrant survivors of abuse. A very powerful tool for victims in those circumstances are, especially if somebody came in on a green card from the abuser, he'll say, if you leave me, I'm going to report you to immigration, I'm going to get you deported. And there's a Pierce County judge actually put in an order in a case that you cannot make those threats, you cannot contact immigration authorities about the survivor's immigration status. And the Court of Appeals reversed that decision on free speech grounds, although did say that if the court had made a sufficient amount of findings that this was intended to harm somebody, that it could be a permissible one. But the courts have to make a really good record in these situations to restrict what's considered somebody's free speech rights. But again, I think it just gets at, again, the form that a lot of tactics that abusers can use don't appear on their face to be illegal. And it's very important to be creative when working with clients in these situations and to give a range of options. I mean, one other thing I could mention on this one is threatening to post intimate images of somebody without their consent. Washington just adopted laws this year that deal with, that establish specific criminal and civil penalties when somebody distributes an intimate image of another person that had been shared privately when they were in a relationship, but after they break up, they threaten to put it all over the internet or send it to, there have been cases where, exes have sent pictures to somebody's grandmother of, nude photos. And so there are laws on that too. It's a little harder to restrain somebody about doing this before, but we have seen courts that have actually said in protection orders that you shall not distribute or you shall return all intimate images of the other person. But it just shows again how, as technology evolves, it really increases the ways that you can control and abuse another person. Okay, so I had a second hypothetical. Carol and Diane have been in a relationship 4 years. Diane sometimes slaps and hits Carol. Diane also made Carol stop seeing her friends and family, claiming they're homophobic. One night, Diane hits Carol and Carol pushes to get away. Diane calls the police, who arrest Carol. Diane is now seeking a DV protection order against Carol. So a couple questions. Why would the police have arrested Carol based on these facts? And we can imagine some other facts in this. And two, if Carol came to the clinic seeking advice, what would you do? So I guess on the first question, here we're describing a situation where the person who initiated abuse was Diane. Carol pushed to protect herself. The police came and they arrested Carol. Why would they do that? All right. Oh, yes. Yeah, and the answer is, yeah, they're only looking at that snapshot in time. If it's a situation where Carol is much bigger or appears butcher than Diane, they may stereotypically view Carol as the person who must have committed the abuse because of those kind of characteristics. It may be that, Diane has a mark on her, or, I hate to say it, inflicted a mark on herself to make it look like abuse. There's a lot of different scenarios that could happen. I mean, the other situation, as we described earlier, that might have happened in this situation is the police just throw up their hands and arrest both of them based on this. But it is definitely a problem when police respond to DV incidents that they may view things stereotypically. If it's a same-sex relationship involving men, again, the relative size might be played into account. And again, whoever might appear to be butcher might be the one who's viewed as the aggressor, even if it's not true. So again, if Carol came to the clinic seeking advice, what kind of remedies could we suggest to her, or responses could we suggest to her? And in a situation like this, I think I would just advise her, if Diane's seeking a protection order against Carol, I think Carol needs to go to that hearing and get as much documentary evidence as she can, statements from friends, for instance, or other people who know what's been happening in the relationship, to show that, in fact, over the history of this relationship, Diane has been the abusive partner and has engaged in other incidents. Ask the court to realign the parties and perhaps give Carol a protection order if she wants to seek that remedy. But I think to get as much evidence as she can, and I do think it's important to get in evidence of things like isolation as well too, that Carol stopped seeing all of her friends because Diane basically said, no, I don't want you to see them. And some courts will recognize that isolation as a tactic. It's not illegal. And a big mistake that a lot of survivors make, and I shouldn't say it's a mistake because it's totally understandable, but when they fill out the petition for a protection order, they don't put in right at the top the conduct by the abuser that meets the legal definition of domestic violence in Washington. They'll talk about the other tactics that the abuser has used that don't meet the definition of domestic violence, like isolation, like yelling. I mean, yelling is not domestic violence generally unless it contains a threat under the legal definition. And other types of conduct. And when the courts are reviewing this petition, they're going to want to see right up front what meets the legal definition of domestic violence. In King County, there's a program that actually helps survivors write good statements when they're seeking protection orders. And I think that might be actually useful for the clinics to have some materials on how to do that. But in this situation too, as an attorney, I think it's also important to recognize your limits. And I would ask Carol, have you seen a domestic violence advocate about this? Have you heard of the Northwest Network, for instance, which serves LGBTQ folks in particular, and see if you can make referrals to them. In Pierce County, I really have had a great relationship over many years with the YMCA of Pierce County, which does a tremendous job of advocacy for survivors too. Did I say the YMCA? Oh my God, yes, the YWCA, yes. I'm going to be presenting on trans issues in about an hour, and we'll get into what we have to say about the YMCA. So here are some resources that I would just suggest to folks. This is not comprehensive, but these are all generally good sources of information. And again, I will put in a strong plug for the Northwest Network because it really is a very unique agency that we're fortunate to have in this part of the country to serve specifically LGBTQ survivors of violence. This is probably unnecessary and it might be covered in other places, but if folks are not aware of WashingtonLawHelp.org yet, you should check it out. It is a tremendous resource. It's maintained by the Northwest Justice Project, and they have self-help packets by the dozens on such a wide variety of issues. I go to their self-help packets when I'm exploring an unfamiliar area of the law, and they do a beautiful job of explaining it in plain language, but still with enough legal citations that you can actually find the sources of the law. And another thing for folks, and I think the clinic will probably, folks with the clinic will probably know this, but you can only do so much in a 30-minute consultation with any client. And it's important to know where to refer folks on. And I will put in a plug for the Clear Line, which is the coordinated intake system for our civil legal aid system in Washington. Obviously, the Clear Line and our civil legal aid system can't help everyone with every problem. I wish they could, and they wish they could. But they do prioritize domestic violence cases involving children for representation in things like family law and getting housing. And it's an important resource to at least let people know about. There are income qualifications for it, but again, the worst thing you can do is call and see if you qualify, because it's really, I hate to say it, but in family law issues, it's almost impossible to get a pro bono lawyer. And it's also almost impossible to get a lawyer for a family law case without paying a $5,000 retainer in most cases. So it's important to try to connect survivors with as many resources as you can. So I think I am at time, and we've got a 15-minute break now. I think 15-minute break? Yes. So thank you.